Good morning, everyone. We want to welcome you to today's webinar on navigating the pathways of vaccine mandates and current COVID-19 litigation. A few housekeeping items to get us started for today. This Zoom is in webinar format, so therefore all of our attendees, your mics are muted and your cameras are turned off. Should you encounter any technical issues, please use the chat feature located at the black menu bar of your screen, and I'd be happy to help you on the back end of the webinar. For any questions throughout the duration of the webinar, please use the Q&A feature so our presenters can follow along with you and make sure we get your questions answered at that time. Alongside a note with that, we will be offering MCLE credit, a copy of the PowerPoint and the recording once it's made available. Those generally take about a week to process, so please give us till about midway through next week and we'll make sure we get those all out to you. At this time, I'd like to introduce Deborah Fox, Principal, and Principal Camille Hamilton Pating. Thank you both for joining us today and delivering this news.
Thanks so much, Steph. I have to confess that I am super excited about this webinar. I don't know how we picked this date, just 3 or 4 days after everything is changing. OSHA regs, the Court of Appeals, the 5th Circuit, the 8th Circuit. This is, just insightful. So as soon as this webinar is over, we'll have to update everything, but let's tell you where things stand as we speak to you this morning. I'm also really excited to be here with my partner, Camille Hamilton Pating. Camille has done much of the transactional work of navigating through for private employers and public folks in the transactional side. And I've been in the trenches of the litigation. But of course, those two sides of the house have to interface. And so here's our chance to do that. If we might go to the next slide, please, Steph. So here's what we hope to accomplish this morning. First off, we're going to give you an overview of vaccine requirements. We're going to talk about what are some key elements to have in your mandatory vaccine policy, and maybe what are the next elements that folks are going to be demanding and how you can be on the cutting edge to anticipate that. We'll talk about what has been on so many people's mind, the religious and medical exemptions. And then as well, the recent union opposition to the mandates, how that has been faring in the courts and in the public sector. And then some legal challenges to the mandates. Some of these issues that we'll explore this morning are about liberty arguments. Everybody's heard it. The government can't tell me what to do. I have a constitutional right to do as I please, to wear a mask, not wear a mask, get a vaccine, not get a vaccine. So we'll talk about that. Underlying all of this is the scope of authority of the government and how broad their powers are. We get to go back to the fundamentals, those of us who are lawyers of law school, to make sure we understand where the power derives from. I will talk about some privacy issues that are at play. We'll try to give you some real life case examples so it'll be helpful in your day-to-day struggles with imposing and understanding what you need to do and can and can't do here. And we hope to have some time for questions. We also have encouraged people to be in the chat. Camille and I'll be monitoring the chat as this is ongoing and trying to answer questions as those come up. And with that, why don't we move to the next slide, Ms. Hill? So we wanted to find out where everybody is. We have a very diverse group here and wanted to get a feel for what type of vaccine policy you have and if you have one at all. So we've got a quick instant poll. We'd like to have you all engaged here. So if you could roll the poll, Stephanie. So if you could tell us, do you have a policy that is mandatory, that it is a condition of employment? Do you have to instead have just a proof of the vaccine to access the office? That happens to be what Meyers Nave has. And I could offer some comments of folks who may not want to access the office, but so far it's worked pretty well for us. Do you have a COVID testing as an alternative? Do you have some different policy or no policy at all? So cast your votes.
And I would jump in here, Deborah, to say one of the themes that we're going to be talking about today are approaches, kind of hardline approaches versus soft approaches to vaccine policy, and also, ways of dealing with vaccine resistance. The first option, vaccine requirement with or without the weekly testing option tends to be more of a hardline approach. The second, providing access to a work site, requiring vaccines for those who are coming into the workspace, is more of a softer option. And that implies that you've got folks who are working from home, or maybe have permission to work from home for an extended period and don't need to access the workspace, or that your organization has already decided that you're going to go forward in kind of a hybrid mode with some folks working from home and some folks there in the office. That's a really important indicator for us to know, where you as our audience are in terms of how we're going to discuss the content to follow.
Thanks so much for that. And here are the results. So 30% of folks have a mandatory. 12% have the Meyers Nave version of required vaccine for access. 25% allow testing as an alternative. 17% have a different policy, and 17% have no policy. How does that compare, Camille, to what you were seeing at earlier webinars?
Well, I see now that, many more of our participants are in line with the mandatory form of policy, which is, and again, this is what we're talking about, the vax or test rule, which, we see from federal OSHA, and this is, the rule that is under so much attack right now, just went into effect on November 5th, and then a day later, the attacks begin. And as of yesterday, I see that there are 2 more lawsuits being filed by religious groups, and we're going to talk a little bit about, all of these forms. But yeah, the mandatory vaccination policy is consistent with our state recommendations, consistent with many of our local health orders. And I think many employers are now looking for that certainty of, being able to assure their employees and to assure the public that interactions with these employees are going to be safe, and that workers who come into the work site are also going to be safe, and that everyone around them will be fully vaccinated. So good job for everyone who has a policy. For those who don't yet or are still developing your policy, we'll talk a little bit further in the webinar about some of the elements that you should be considering as you're putting your policy together. Deborah? Thanks
so much, Camille. Let's go to the next slide. This is setting the stage about what we are seeing in California. Some stats about the number of cases, the number of deaths, and of course, that number is pretty staggering, of 72,000 plus deaths in California. I think we all are very anxious now as we turn the corner into the winter months. We all remember last December and the holiday seasons that we spent at the stay-at-home orders. Of course, that was before the vaccine, and now many are saying that this is an epidemic amongst the unvaccinated. But again, I think it's important to be thinking about this, especially as we now know that travel is open both internationally and along with people getting ready to travel more for the holidays. The importance of the vaccine is only heightened. And if we might go to the next slide, please. This one I find very interesting. In California, it shows that we have about 74.9 or 75% of folks have had at least one shot throughout the state. And then you can see the categories for age. We'll have some discussion a little later on too about some of the various groups, including first responders, healthcare workers, etc., as to their vaccination rate. And if we might move to the next slide, please. So This is what we're hoping to help you do, is to how to navigate the resistance that is now coming forward to these mandates. Folks have fatigue. They have fatigue from the government telling them what to do. They have fatigue from the pandemic in general, and this is really coming out more and more. So how to navigate that resistance? What are the appropriate responses? Camille always has good ideas of how to have some sort of resolution without getting into litigation. And so let's start exploring those. I want to start though with what happened on Saturday morning. If we go to the next slide, Stephanie. The tagline that has come forward is jab or job. And of course, President Biden imposed a mandate for vaccination requirement, which would apply to about 84 million workers, any companies with 100 plus employees, setting a deadline for January 4th. And I want to sort of highlight that. Every time we come towards deadlines, we are going to see more and more litigation. And also what we found in the COVID litigation is that weekends are not exempt from orders. In fact, I used to kid that every Friday night between 9 p.m. and 11, you could be confident you would get a ruling from the Ninth Circuit or Scotus. I think we're moving into that same sort of heavy action with the Circuit Court of Appeals, etc. So as you may all know, the federal OSHA requirements for the unvaccinated are weekly testing and the need to wear face masks. Camille, you want to talk a little bit more about the OSHA?
Yes, next slide, please. So as had been anticipated, the Department of Labor issued through federal OSHA the vaccine or test emergency regulation. And we refer through OSHA, whether it's Cal OSHA or federal OSHA, the emergency temporary standard, or we call these the ETS. And the ETS is something that for those of you in HR, as well as counsel, we have to look constantly because the ETS, both for Cal OSHA and for federal OSHA, is always being updated. In this case, on November 5th, we saw federal OSHA's ETS updated, essentially requiring employers to establish, implement, and enforce a written mandatory vaccination policy. The ETS required employers with at least 100 employees to ensure that their workers were fully vaccinated or submit to weekly COVID-19 testing. And as Deborah has indicated, we immediately saw a litigation response to that. That's going to affect over 84 million private sector workers. And it is one of the most forceful steps that's been taken by the federal government to address the pandemic. So basically, the ETS provided two pathways for compliance. Number one is that all employees had to be vaccinated unless they qualified for a medical or religious exemption. And it's important to note that if you're one of those employees who qualifies, you still, even if you have a qualified exemption, you still have to submit to weekly testing and you still have to comply with the face covering guidance. And the second way to comply was to show proof of vaccination status and participate in at least once weekly testing. There's also an issue about who pays for this testing, who pays for the cost of it, because the federal ETS noted that employers are, quote, not obligated to reimburse employees for incidental costs incurred for vaccination. And that would include, presumably, the cost of transportation, the cost of gas to go and get these tests. But, you know, here in California, we have additional laws. We also have many employers, especially public employers, have MOUs that specifically would relate to an employer being obligated to pay for those types of expenses. So as we skip ahead to this type of issue about, you know, who pays for the cost, generally speaking, well, first we want you always to look to your MOU. You should always be consulting with your counsel about these types of costs, but always look to California law as well. Deborah?
Thank you. So now the big drum roll, and next slide, please. This is the Fifth Circuit injunction that came out on Saturday morning, so November 6th. It stays the enforcement of the emergency measure by OSHA that Camille was just talking about. It ordered expediting briefing. That's the great thing about COVID litigation. Everything's expedited. So the government filed its opposition on Monday. The reply brief was filed on Tuesday. That was the 9th. I think we will expect an order from the Fifth Circuit probably by the end of the week at the latest. We're definitely on the road to a run up to Scotus, but let's talk a little bit about what happened here and what it means. Okay, so the court issued an emergency stay motion and said that there were grave constitutional issues at play that needed to be addressed. The court, in its order, which was a whopping 3 paragraphs, said that the order was not precedent. And nevertheless, people are asking, does this apply throughout the nation? Of course, California is not in the Fifth Circuit. We're in the Ninth Circuit. Nevertheless, people are generally saying that this was requested to be nationwide. But I'm going to say it really doesn't matter because this is a temporary stay and the deadlines that are at play are not till the beginning of December and the beginning of January. So we are going to have a more definitive ruling and clarity on whether or not, as a matter of procedure, this injunction would apply in California. There's going to be a lot of action already though. So curious here about the members who were challenging the order here by the federal government. Those include several states, Texas, Louisiana, Mississippi, South Carolina, and Utah, private businesses, the Word of God Fellowship doing business as Daystar TV Network, along with a number of private entities. So you have a very broad coalition. And then as well, I just found out on Friday night as well, a number of additional Republican governors sought action in the 8th Circuit, filing in St. Louis. There you have Missouri, Alaska, Arizona, Montana, Nebraska, North Dakota, South Dakota, and Wyoming. So what we anticipate is going to happen here is something in the federal procedure that we don't see a lot, which is a multi-circuit coordination. So we're all going to become experts in the federal rules of civil procedure. I'll confess, I've litigated in federal courts for 30 plus years. I've never seen this, but hang on to your hats. We're going to figure it out together. Again, though the case, the arguments being made in this case is that this temporary measure violates due process. There was no notice. There wasn't an opportunity for public comment, and goes to the heart of the issues that we have seen on the forefront about separation of powers. And so the argument is here that this would need to be a measure adopted by Congress, and that the Biden administration exceeded its authority in the imposition of this mandate that applies to 84 million workers across the country. I do want to preview a case that we have later on in the slides, which is called Jacobsen versus Massachusetts. It's a 1906 case that we've been using throughout COVID, which dealt with Massachusetts' requirement for a smallpox vaccine. And I just think it's curious there because the only case law we have deals with one state, but now we're on a much bigger scale. So I think it's going to be interesting to see how those arguments play out on this bigger stage. And I want to check because this was so riveting. I was up late last night reading all these different filings that had happened. So remember, the deadlines that are at play are December 1st. December 5th is the deadline for having masks indoors, and January 4th related to the COVID vaccine mandate. So as those dates approach, I think we're going to see more and more legal action and more legal rulings. So while you're eating your sweet potato or pumpkin pie over Thanksgiving, be sure and check your computer for the latest rulings. I guess the question is a practical pointer. What should you do? Should you just stop and wait till we get some direction here? And again, I think because of the fact that these deadlines are further out, it is prudent to keep moving forward in the processing of your regulations and moving forward in however you have decided to address these in the workplace. And indeed, I think it was yesterday at the press conference, President Biden urged everyone to keep moving forward, keep pressing on. But Camille, do you have some thoughts on that?
I think that the point that you just made, Deborah, about moving forward, that's the question that I'm getting the most from people is, wow, there's so much, confusion. And of course, as we keep saying, as we've been saying for the last 19 months, the landscape in COVID is changing on a daily basis. So what should we do? Let's go to the next slide, please. And I think that moving forward is the right mindset and the right approach. Remember that, the whole purpose of having vaccine policy is to provide certainty, of public safety, is to provide certainty of worker safety, and is to allow employers to really prepare and implement their return to normalcy, return to office, return to work site. It's to facilitate all of that. And so that's the reason why so many employers were really happy to see the federal OSHA rule. And the fact that it's going to play out in the courts really is not going to impact California employers to the extent that, we're still under the state recommendation. So all throughout COVID, we've been talking about the interplay between the federal, the state, and the local. California employers are obliged to follow federal, which previously was CDC, now is the Biden vaxxer test rule. We were obliged to follow state recommendations and state regulations, Cal OSHA's ETS guidelines, and also local health orders. Every county has a health officer who's issuing their own orders. And many times these orders were not always consistent with each other. And that's the reason why, I'm going to say it over and over again, that as you as employers are navigating these difficult tasks of making sure that all of your policies are in alignment with federal, state, and local, make sure that you're consulting with counsel who can help you guide through your individual situation, because since especially local health orders vary from place to place, it's very important that you have that individualized attention. So here, as we see, and this is sort of a review for the 30% of you plus that already have your policies, which are already in alignment with your California state recommendations and your local orders. But for the 17% of you who are creating, this is what you need to be aware of. Our California state recommendations, and this is updated from the most recent October 28th, provide that employers need to follow Cal OSHA's ETS guidance. Employers must also follow public health and local jurisdiction requirements where they exceed Cal OSHA standards. And the federal ETS, OSHA ETS, was the same. saying that if you're in a state that has Cal OSHA, which California does, if our standard is higher, we need to follow the higher standard. So currently, Alameda County, so Alameda County is an example because just last week here in Alameda County, we moved to a rule that in a workplace where indoors, where all employees are fully vaccinated, you are not required to wear a face covering inside. The counties of Alameda, Contra Costa, Marin, Napa, San Francisco, San Mateo, Santa Clara, and Sonoma are going to lift indoor masking requirements in public spaces when the following things occur. Jurisdiction reaches the moderate yellow transmission tier, hospitalizations and in each jurisdiction are low and stable in the judgment of the health officer, and 80% of the jurisdiction's total population is fully vaccinated with 2 doses of Moderna or Pfizer or 1 of Johnson & Johnson, and the booster doses are not considered. Or 8 weeks have passed since a COVID-19 vaccine has been authorized for emergency use by federal or state authorities for the 5 to 11-year-olds.
So Camille, can I ask you a quick question?
Yes.
You know, you and I are, staying up late at night trying to find out what the current state of the law is. What are you recommending to folks when the federal, state, and local orders conflict? Should they follow the most restrictive guidelines, or how should folks proceed?
Yes, you always want to make sure that you're in compliance with all 3, and that usually means that you're in compliance with the most restrictive guideline. But as I said, each situation varies, and if you have particular questions about whether or not your entity or organization is in compliance, please be sure to ask counsel. Next slide, please. Okay, let's go quickly through the elements of a vaccine policy. As I said, this should really be review for those of you that already have your policies, and a tip or pointer for those of you who are still in construction. So the elements generally will have three aspects. Number 1 is the purpose. And here's the statement of purpose. We usually provide this to provide, as I said, the safe and healthy workplace consistent with public health guidance and legal requirements to protect employees and the public as we reopen services. You can consider inserting additional statements about the impact of mandatory vaccination of employees on the safety of workers' families, of customers, visitors, business partners, also the community. And this language here is in full compliance with OSHA's ETS. In terms of scope, there needs to be a statement about who is this applying to and why. This policy will apply to all employees of employer. And in the case of Cal OSHA, there is a case of the OSHA ETS, there were exceptions for those who did not report to the workplace when other coworkers or customers were present, employees who were working from home, employees who worked exclusively outdoors, and those that were not otherwise covered. And generally speaking, in your policy, if you have those kinds of exceptions, you want to identify them. Next slide, please. Okay, the third aspect of the policy should be the procedures. And this is going to include what's required in terms of reporting vaccination status to the employer, what's required in terms of establishing proof of vaccination that the employee is fully vaccinated, and then to identify when the fully vaccinated date occurs. And generally speaking, the acceptable proof of vaccination required would be record of immunization, copy of the vaccine card, medical records documenting the vaccination, other form of medical record. And if those were not available, then many employers also allow attestation for an employee to provide a statement basically that they have been vaccinated and the dates in which that occurred. So under this type of policy, all employees are required to be fully vaccinated as a term or condition of employment, and stating that they will be considered fully vaccinated 2 weeks after completing primary vaccination with a COVID-19 vaccine. Next slide, please. And then also including the statement as to unvaccinated employees being required to submit to testing and also to wear a face covering. And as I indicated, the unvaccinated employees category includes both those who are choosing as an option to submit to testing rather than provide proof of vaccination, and those who are exempt from the vaccine mandate because of a qualified religious or medical exemption. So now we're going to talk a little bit about some of the ways that these elements have encountered some resistance. And the first area is in face masks. Deborah, you want to give us some information about the face mask challenges?
Sure, the great face mask debate. If we could go to the next slide, Steph. I had a friend of mine who was just visiting from Atlanta, and she was traveling from LA to Orange County to San Diego County. And all of those counties have different face mask requirement. And one of her other acquaintances said, "Why are you wearing a mask?" And her answer was, "I don't know." And so wearing a mask to try to be in compliance. But this is, I guess, a personal favorite of mine. I happen to be a constitutional lawyer. And people were saying, as they are about the vaccine, that I have a constitutional right not to wear a face mask. So I'm like, do you? Answer, no. So here is, and the reason I want to put this in here, and I think it will be applicable as we see the litigation unfolding on the vaccine mandates, because you need to have a protected interest. Speech is a protected interest, but the question is the woman on the right, is she communicating some speech? And is the woman on the left communicating some speech? Camille made me change this photo because it did have a Black Lives Matter on the mask. Of course, you've had seen, I'm sure, some folks that have, you know, the government made me wear this mask. That's a whole different topic, and that's clearly protected speech, but we're just talking about wearing a mask without any elements of communication on the mask itself. And if we might go to the next slide.
Sure, I just want to chime in here and let you know we're about halfway through the presentation.
Okay, great, thanks, Steph. Okay, and so this is the test. I'm not going to spend a lot of time on it, but it's whether or not you are intending to convey a message and somebody would understand by what your action that you indeed are communicating such. And if we might go to the next slide. Another personal favorite case of mine, and I think the League of California Cities made me cover up the barista who was wearing a bikini. She said that wearing the bikini was communicating how she was body confidence and body acceptance. The Ninth Circuit rejected that argument and said that clothing, plaintiff's wardrobe selection, did not constitute expressive conduct within the First Amendment. And I think the next slide that we go to, if you would be so kind, Stephanie, will also be of interest in this issue about public safety. So it's interesting that this is another case that came out of Orange County. This particular gentleman challenged the motorcycle helmet law. He said that it was a violation of his freedom of religion because he wanted to drive on a motorcycle without a helmet over his religious head covering. The court said that that challenge did not survive. It said that the law was rationally related to a legitimate safety concern and did not impermissibly infringe on constitutional protective rights of religion, freedom of expression, or right of privacy. I think we see arguments along these lines about public health, of people having to wear seatbelts. I think we've heard some analogies, and Camille may want to jump in here, about being able to impose requirements in the workplace of wearing protective eye gear or headgear, etc. And I think those safety concerns, I think it's interesting how the court weighed those here when you did have a First Amendment issue at play. And with that, I think I pass the baton back to the next slide and to talk about religious accommodations, which I'm going to be listening with close ears here, Camille.
So religious accommodation and medical accommodation are traditional areas in Title VII that employers need to be mindful of and need to address with any kind of rule. And here with the ETS rule, it's no exception. What's interesting is that religious accommodation has become, or may become, a venue for holdouts to the vaccine, and may become a way that folks can express their opposition, and is being expressed as a concern for employers. I think that one of the important things that we're going to be looking at as we continue to do this analysis is, what is the impact on your work environment of the holdouts? Either folks because of requests for religious exemption or requests for medical exemption. Is it a relatively small number of people? Is it a large number of people? Employers have different approaches, and we're seeing, in terms of the issues that are being brought forward to us, a number of different approaches that employers have. Again, as I say, between the hard line and the soft approach of, okay, we're going to take your request for an exemption at face value, or no, we're going to do a deeper dive. We're going to look to see if this is really a sincerely held religious belief. And there are concerns or potential risks about how an employer approaches those kinds of requests. Next slide. Okay, so let's look at some of the situations where some employees have expressed their concerns about refusing vaccine. Number A, an employee who obtains a doctor's note not to take the vaccine, and the rationale is because it would make him nervous. It would make him nervous to take the vaccine. B, an employee who is fearful that the vaccine could impact her ability to get pregnant. Could impact her ability to get pregnant. C, an employee who has an autoimmune disease provides a doctor's note that she should not get the vaccine. And D, someone who sincerely doesn't believe in vaccines. Okay, we were going to walk through these, but I think in the interest of time, I'll just say, if you have an opinion about any of these scenarios, why don't you drop them in the chat and let us know if you're experiencing these types of scenarios. So, the doctor's note, and we'll talk about this, of the employee who would be nervous, taking the vaccine. Well, that's somewhat problematic. The doctor's notes in general, health providers' notes in general are not to be challenged. But one of the issues that comes up in vaccine refusal are people who are fearful, people who just don't want the vaccine, or people who have a political objection, or a liberty-based objection, as Deborah is describing. And those are the areas that are red flags for us. The employee who is fearful that the vaccine could impact her ability to get pregnant. The EEOC just recently came out with new guidance last week indicating that that employees who are pregnant, hope to be pregnant, or are currently pregnant, should be able to get the COVID-19 vaccines. But here is one of the arguments that we frequently see about concerns that this might impact my fertility because of quite a bit of misinformation that's out about COVID vaccines. C, the autoimmune disease. Okay, that's an easy one. You have the doctor's note, you have an autoimmune disease, that's a medical exemption. Someone who sincerely just doesn't believe in vaccines. Okay, well, the sincerely word is triggering, oh, this is sincere, but no, it has to be a religious belief. It has to be a sincerely held religious belief. It can't be just that you don't believe in vaccines. Next slide, please.
So Camille, I wanted to add a couple more in there. I wondered, and I put out in the chat for the group, I wondered if anybody is getting requests for an exemption based on the fact that an individual has previously had COVID, been exposed to COVID, and believes they have the antibodies. And I'd love to hear from anybody if that is coming forward. I told Camille that I thought this was going to be a challenge, and I hopefully Camille will vouch for me that I said that, because I just found out there's a class action that's been filed against Dr. Fauci by folks who say there should be an exemption for the folks who have the antibodies. So I think that we should be thinking about that and offer that to you all as you are moving forward with these policies. I also find it interesting whether or not the issue of if you're going to be able to claim a First Amendment right because you have a political belief. I don't think that's going to get much traction, but I'm going to predict we're going to see that as well. That I believe from my political point of view, and that is my First Amendment right, that I should not be taking this vaccine. So I'm just going to put that out there in the universe, and we'll see what happens during the COVID litigation.
So I think that the point that Deborah is making, is very important in that there are these two tracks for refusal for vaccination. A constitutional track in which, Deborah is giving us the basis of her expertise in this area, litigation, constitutional objections, and then under Title VII, objections based upon potential exemptions. So these are the areas, I think, where many of our employers are seeing or navigating some of these issues. The medical exemption requires a doctor's note that must establish that the exemption from vaccination requirements is necessary for the employee to perform the essential functions of his or her job. Okay, and as such, what the feedback that I'm getting is that this has not been a significant source of opposition. Medical exemptions generally, because you have a health provider note, are pretty straightforward, and usually they represent a pretty small population of folks who potentially could be vaccine holdouts. And so, correct me, folks in the chat, if you're seeing something different. But my sense is that these requirements are pretty straightforward. The provider's note is given, and the medical reason is given, and that exemption is usually pretty cut and dried. I did want to just add on the statement that the EEOC made. So the EEOC has updated its guidance. It's called What You Should Know About COVID-19 and the ADA, the Rehabilitation Act, and Other EEO Laws. The new update was dated October 28th. And there was some specific language about vaccines and pregnancy that EEOC is citing the CDC's recommendation of COVID-19 vaccinations for everyone age 12 and older, including people who are pregnant, breastfeeding, trying to get pregnant now, or planning to become pregnant in the future. So despite these recommendations, EEOC is also indicating that Some pregnant employees may seek adjustments or request exemption from vaccination, and that if a pregnant employee seeks an exemption from the vaccine requirement, employers do need to take care to ensure that the employee is not being discriminated against compared to other employees similar in their ability or inability to work. Okay, so just flagging that issue of making sure that pregnancy does not become a basis for differential treatment. Next slide. So let's talk about the EEOC exemptions. And here's where I'm talking about the hard line versus soft exemptions. Soft exemption is that, you know, you state your sincerely held religious belief, and it's more or less accepted by the employer without any inquiry. Hard line allows for some questioning about the sincerity of the belief. So EEOC has recently spoken to this, stating that on the issue of whether an employer has to accept an employee's assertion of religious exemption at face value or can ask for additional information. And remember that generally speaking, the courts say that great deference should be given to an employee's statement of a sincere religious belief. EEOC says, generally under Title VII, an employer should assume that a request for religious accommodation is based on a sincerely held religious belief. However, if an employer has an objective basis for questioning either the religious nature or the sincerity of a particular belief, the employer would be justified in making a limited factual inquiry and seeking additional supporting information. Okay, so although here we have a little bit of the balancing, although EEOC is saying that if there's an objective basis for questioning, the employer can seek additional information, but caution, because we know that the courts give a high level of deference. And again, here I would say, look at, you know, how are these requests for exemption affecting your workforce? Next slide, please. Your goal here is to have an interactive process with your employee to see if you can resolve the conflict between the employee's objection and your vaccine mandate. And you know, one of the issues that's been raised is that at least as of currently that I'm aware of, no organized religion, no organized religious leadership have come out against vaccines. In fact, in terms of the Catholic Church leadership, I think Pope Francis actually stated that getting the vaccine was a moral thing to do because of the protection not only of oneself, but also of others in the community. Notwithstanding that, it can be very dangerous to be inquiring or testing the sincerity of an individual's belief because of the great deference that's provided by the courts. And here, just remember that.
Camille, I've heard folks asking questions about whether or not you've gotten other vaccines, whether or not you've gotten the flu shots, whether or not you have taken certain medicine, or I was even hearing whether or not you even take Tums, that somehow that's been equated with some sort of stem cell usage. So do you have any thoughts on whether or not folks should be asking those kinds of questions of their employees?
Well, again, this is the distinction between the hard line and the soft approach, right? That I have heard that some have asked about, you know, are you taking other vaccines? But usually the issue that's being raised regarding the sincerely held religious belief is that stem cells were used in the development of one of the vaccines. I think not the other two that I'm aware of. or that there's some biblical reference to the body being a temple, and that some individuals have, embraced that or are putting that forward as part of their sincerely held religious belief. Again, I think it's a case-by-case determination, and it's very important if you are denying religious accommodations based upon a belief that there has not been sufficient objective proof to establish the sincerity of the person's belief. Please be sure that you're consulting with counsel on a case-by-case basis. And yes, these are the issues that are being brought forward, and each one needs to be analyzed, I think, individually. But I just put that cautionary note out there for folks that, there are dangers with doing the deep dive into a person's sincerely held beliefs, and really be guided by, what is really the impact of this on your workforce? Do you really have a large number of people who are trying to opt out because of the religious exemption?
We're getting a couple questions about whether or not you can opt out of weekly testing based on religious objections.
That's interesting. I think that, that's something that definitely should be referred back to counsel so that we can work with you about, what is the basis for that objection. Remember that requests are not going to qualify if they're based on personal preferences, the effects of the vaccine, or political opinions. Next slide. Okay, so let's talk a little bit about union opposition to vaccine requirements. We have heard from some sources that many public entity clients are seeing low vaccination rates among public works workers, among maintenance workers, and also public safety workers. And we know that, many have already gone through the meet and confer process with their unions. This is required under the Myers-Millis-Brown Act. Even though we have arguably an emergency situation because of the pandemic, it's advisable to get your labor unions on board for your vaccine policies as much as possible. And a lot of this involves communicating with those bargaining units about the need for your policy in terms of protection of their own members, protection of the workforce, and protection of the public. So those are always important. But let's talk a little bit about some of these specific groups. Next slide.
Camille and Deborah, I just want to let you know we have about a little more than 5 minutes left.
Okay, we'll go quickly. So what about police officers? I think, Deborah, we've been monitoring what's been happening in Los Angeles, where police officers union challenged LA City's mandatory vaccine requirement. Do you want to fill us in just a little bit about what the outcome was of that challenge?
Yeah, well, there have been a couple of challenges, both by the LA firefighters along with the city police department. Those both cases were requesting some sort of injunctive relief, and those both requests were denied. Of course, the final word isn't in on this federal litigation. I would say, though, that again, it's all timing and deadlines. So at least down here in Los Angeles, the deadlines aren't coming up till December. So if you're going into court and you say, you have a emergency, that time frame for the emergency, you need to be closer to the deadline. But what was really interesting is some of the stats that came out this morning. As that deadline approaches, the LAPD says now 78% of their police personnel have received the vaccine. And that's very interesting because that was an increase of the compliance because they had hand-delivered notices to the unvaccinated employees informing them they must start paying for the testing. and be vaccinated by December 18th, unless they had the religious or medical exemption that Camille was referring to. Equally interesting is that the LA Fire Department says that they have a compliance rate of 70%. But they also put forward that they have had to spend $22 million on overtime for firefighters to cover those who were ill from COVID since the pandemic started. So I think we're going to see some interesting arguments about how you can impact the police force and save the public taxpayers money with the vaccine mandates. Also, I wanted to just offer the comment that is being made in the Fifth Circuit case, which is that employers are concerned that because the number is 100, that they're going to lose employees to smaller employers who won't have to comply with the mandate set forth by the Biden administration. So if I can move to the next slide, please. Down here in Los Angeles, our sheriff has been in the news quite a bit. He has been saying extensively that he believes he's going to lose and he doesn't want to lose his workforce. He's saying that response times will go up, that crime is increasing, and accordingly has really been pressing hard that he will not be the vaccine police. One thing we haven't talked about, but it's again could be a whole other seminar, is the fact that the issue of enforcement and who is going to be enforcing these various mandates. And I think again, on enforcement, you're going to see continuing fatigue. I think there's a lot of political upset about businesses being put in the position of having to enforce these vaccine mandates that are now imposed for going to restaurants, etc. If we might move to the next slide. We are running out of time. So this is the Jacobsen case that I talked about. It was cited extensively in the religious challenges that started us out at the beginning of the pandemic. Let's move to the next slide. And actually, let's go to the slide on the John Doe's, which is one more up, I think, Steph. I think this is an interesting case. This is Scotus. So Scotus denied an injunction regarding a healthcare worker's challenge to the vaccine mandate. The application was denied from the state of Maine. The governor's provisions had no religious exemption. So I think that's kind of a surprising ruling, but remember, whenever you have these preliminary injunctions, the standards are markedly difficult to meet. So there could be other underlying facts that dictated this. I would say that obviously if you don't have a religious exemption, you're going to be in big trouble as far as the legal validity of your mandate. If we might move to the next slide, which is the scope of the executive power. In the state of California, we have established case law. And if we go to the next slide, Stephanie, this is Gallagher versus Newsom. This was about a action by the governor to allow for mail-in ballots in the November 2020 election. It was challenged as a violation of the separation of powers. The court ultimately said that there's broad powers under the ESA, including the power to legislate. So it was interesting because originally when COVID litigation started, decisions were coming out from the federal courts that were not pro individuals, that were supporting all of the mandates. And so folks were going to state court, particularly in California. Then we had the clarification from Gallagher. Then we had the change in the composition of the Supreme Court. And now we're seeing a run up on the vaccine mandate about the issue of the scope of the executive power. So stay tuned for how that's going to unfold. I think we may have exceeded our time. And so I will just offer one other comment about vaccine passports, which is 2 slides up, to say no one wants to use the word vaccine passport. So everybody creates a euphemism for that. We have Safe Pass LA, and other jurisdictions accordingly are creating mandates for vaccines, for dining, for travel, for work, etc. So I am going to pass it back to Camille if you want to give us any parting comments for the greater group.
So let me just sum up very quickly, and this is in terms of the takeaways for you employers, especially you who are have your policies and have your holdouts and are concerned about, you know, am I going to need to take disciplinary action, or those who are putting policies together. It's difficult to balance, you know, the public's right to be safe with the issue of termination. But again, this really comes back to what is the impact of the holdouts on your organization or your entity? Is it a severe impact? If it is, then that's going to be, you know, one consideration. But if it's not that severe, many employers, you know, determine just to go ahead and grant those exemptions and move on and say, okay, now we're in compliance. The other thing to be concerned about is creating multiple types of exceptions that can lead to disparate treatment of employees. You know, multiple classes of people who are allowed to work from home, or multiple classes of people who are allowed to do different things in order to avoid compliance. Those situations generally can create concerns. Regarding diversity and inclusion, I do want to just say this. One of the things that we hear is that a number of employees who are not complying, there may be a disproportionate number who are minority employees. And you also need to consider, if you're looking at discipline for employees who are not in compliance, what is the demographic impact of that? And many employees who are members of minority groups have been disproportionately affected by COVID in general, disproportionately affected by hospitalization rates, infection rates, death rates. Many employees who are Black and brown in general have been disproportionately impacted by being essential workers, and therefore more at risk, more exposed to COVID throughout the pandemic. And as the impacts of failure to comply with vaccine mandates roll out, please consider whether those impacts are disproportionate on those employees who are minorities in particular. And as always, consult with your counsel before taking any type of action based upon failure to comply against individual employees. Thank you so much, everyone, for your attendance. And I apologize that we ran a little bit long. Your questions that are dropped in the chat, we will get back to you. I think Stephanie can indicate for us how to get in touch with you. And so we will answer your questions. Thank you so much for your attendance and your interest today.